No lawyer, a borrowed pencil, one prisoner, about to beat the Supreme Court, 9-0. In 1963, almost no one in America had heard the name Clarence Earl Gideon. He was a drifter, in and out of trouble his whole life, sitting in a Florida cell for a crime he swore he did not commit. He had stood in a courtroom and asked the judge for one simple thing: a lawyer. The judge said no. And that single word, no, is where this story actually begins. Here is something most of us assume is just permanently true: that if you are arrested and cannot afford a lawyer, the court has to give you one. We treat it like a feature built into America from the start. It was not. For most of this country's history, if you were too poor to hire a lawyer, you could be put on trial alone. One frightened person against a trained prosecutor whose entire job was to convict you. The guarantee of a free lawyer is younger than your grandparents, and it exists because of one stubborn prisoner, one handwritten letter, and one unanimous decision in 1963. Over the next 12 minutes, how a man nobody believed in forced the Supreme Court to rewrite the rules of every criminal trial in America, and the imperfect system that ruling left behind. Start in a Florida courtroom, 1961. Clarence Earl Gideon is charged with breaking into a pool room and stealing a little money and some bottles of drink. Under Florida law, a felony. He is poor. He has been in and out of prison before, and he knows the way you know a thing in your gut that he cannot do this alone. So he asks the court to appoint a lawyer for him. The judge tells him the law does not allow it. In Florida at that time, a free lawyer was provided only when a person's life was on the line, in a death penalty case. Gideon's case is not one of those. The chair where his lawyer should sit stays empty. Picture what a trial actually is. It is a contest with rules. Rules about what evidence can come in, which questions can be asked, what a jury is allowed to hear. On one side stands a prosecutor who has done this hundreds of times, who knows every one of those rules by heart. On the other side now stands Gideon. No training, no preparation, trying to defend his own freedom in a language he does not speak. He does his best. He makes an opening statement. He questions witnesses. He argues to the jury. But doing your best is not the same as knowing what you are doing. The verdict comes back guilty, and the court sends him to prison for 5 years. For almost anyone else, that is the end. A poor man convicted, locked away out of moves. But Gideon has one move left that no one expects, and it costs 5 cents. In his cell, Gideon does something quietly extraordinary. He gets hold of a pencil and some prison paper, and in careful hand-printed letters, he writes directly to the Supreme Court of the United States, asking them to hear his case. He cannot pay the court's fees, so he files as what the law calls a pauper, a person too poor to pay. No firm is behind him. No famous attorney is making calls. It is just one prisoner arguing that what happened to him, being tried without a lawyer, was not just unlucky, but unconstitutional. And here is the wall standing directly in his way. 20 years earlier, in a case called Betts versus Brady, the Supreme Court had already looked at almost this exact question and had ruled the other way. Betts said that states did not have to hand every poor defendant a lawyer. A free lawyer was required only in special circumstances. If you were very young, or could not read, or the case was unusually complex. An ordinary poor man, in an ordinary case, was expected to manage on his own. So, Gideon is not just asking the court to help him. He is asking the most powerful court in the country to admit it had been wrong, to overturn its own decision and rewrite the rule for every state at once. Prisoners send the Supreme Court thousands of these handwritten petitions every year. The court turns away almost all of them. It did not turn away Gideon's. The justices agreed to hear the case and then did something that turns the whole story on its head. The man who had been denied a lawyer in Florida was now given one of the finest lawyers in America. The court appointed a top Washington attorney named Abe Fortas, a future Supreme Court justice himself, to argue Gideon's side. The question was no longer just about one man in one cell. It had become a question about every poor defendant in the country. Did the Constitution promise them a lawyer, or didn't it? On March 18, 1963, the Supreme Court answered, and this time the answer was not close. The decision was unanimous. Every single justice agreed. Justice Hugo Black, writing for the court, delivered the ruling. The reasoning was almost startlingly plain. The Sixth Amendment promises anyone accused of a crime the assistance of counsel, the help of a lawyer. The court said that promise is not a luxury or a formality. In our system, where the government hires trained prosecutors and builds courthouses and writes the rules of evidence, a lawyer is not a frill. A lawyer is a necessity. Without one, the trial itself is not truly fair. And because a fair trial is a basic right, the court held that right cannot stop at the federal courthouse door. Through the 14th Amendment, it binds the states too. From that day forward, any state putting a poor person on trial for a serious crime had to give that person a lawyer. And if they could not afford one, the state had to provide one. To say all of this, the court had to do the thing Gideon had dared to ask for. It reached back and overruled its own precedent. Betts v. Brady in the wall was knocked down. The old special circumstances test was gone. The new rule was simple enough for anyone to understand. If you are too poor to hire a lawyer, the state must appoint one for you. A handwritten letter from a prison cell had just rewritten the law for the entire country. But it had not yet done the one thing Gideon cared about most. Because winning at the Supreme Court did not set Gideon free, it did something narrower. It threw out his conviction and sent him back to Florida for a brand new trial. The same charges, the same town. But this time, the empty chair was filled. Gideon walked into that second trial with an appointed lawyer beside him. And the difference was night and day. A real defense attorney picked the case apart, testing the witnesses, poking at the state's story, doing all the things Gideon had never known how to do alone. This time, the jury came back with a different word: not guilty. Sit with that contrast for a second. The very same man facing the very same accusation. Alone, he was convicted and sent to prison. With a lawyer, he was acquitted and walked out free. Nothing about Gideon had changed. The only thing that changed was whether anyone in that room was standing on his side. That gap between facing the state alone and facing it with help is the entire reason the right exists. And Gideon's win did not stay with Gideon. His name became the key that unlocked the same right for everyone behind him. Across the country, states had to build something new to keep the promise the court had just made. Offices full of lawyers whose job is to defend people who cannot pay, the public defenders. If you have ever heard the phrase, "a public defender will be assigned to you," that system traces back in large part to a prisoner's pencil. But this is where the hidden room opens, and it is not a tidy victory. The court could create the right with a stroke of the pen. It could not, with that same pen, pay for it. A right to a lawyer is only as real as the lawyer you actually get. And in the decades since, public defenders have often been buried. Too many clients, too little money, too little time for each case. The promise is guaranteed on paper. Whether it is fully kept, case by case, still depends on resources no court can simply order into being. So Gideon answered the question Miranda would raise 3 years later. When a suspect is told, "If you cannot afford a lawyer, one will be appointed for you," those words are not a courtesy. They are a promise, and it is Gideon's promise. Step back, and the shape of it is almost hard to believe. We did not get the right to a free lawyer from a great speech, or a famous senator, or a crowd in the street. We got it because one poor, twice-doubted prisoner refused to accept that justice was something only people with money could buy, and because he wrote it down and mailed it in. Clarence Earl Gideon got the ending you almost never get. He won at the highest court in the land, and then he won his freedom too. But the thing he really won was never just for him. He won a rule that in an American courtroom, you do not have to face the full weight of the state with an empty chair beside you. That is the hidden system behind a phrase you have heard 100 times. You have the right to an attorney is not set dressing. It is a promise paid for by a prisoner with a pencil. Powerful, real, and still, to this day, unfinished. Next time, we open the door on who decides what counts as a crime in the first place. Until then, now you know who actually gets a lawyer and why.